All right. Everyone, and welcome back to Tea Time with the Robert H. Jackson Center. Today, I cited that our guest is Stephen Vladeck. He is a professor at the University of Texas School of Law, an appellate litigator who has argued multiple cases before the U.S. Supreme Court and the lower federal, and a nationally recognized expert on national security law and the federal courts, fields in the shadow of Justice Jackson looms especially large. Together with his friend and colleague, Bobby Chesney, Vladeck co-hosts the popular National Security Law podcast. He is a 2004 graduate of the Yale Law School and a 2001 graduate of Amherst College, where he wrote his undergraduate thesis on the war crimes trial after the First World War, which was a new bit of history for me. So, Steve, thank you so much for being with us today.
Thanks for having me. It was new for me too.
Good. Well, so we are talking today about executive power and the Defense Production Act, but we're actually going to start back in history. So when you and I were chatting originally, we were talking about how the evolution of this, or the genesis of this, is even farther back than most people think of, with Truman and steel seizure in the Korean War era, but actually probably goes back to some of the World War II era cases. And let's start with the destroyers for bases.
Yeah, I mean, Jackson's such an interesting figure when we're thinking about executive power, because he really had such a rich background even before he comes to the Supreme Court. He spends time as FDR's Solicitor General, where he's representing the federal government in all litigation before the Supreme Court. He spends a pretty important period of time as FDR's Attorney General, in a time, in a moment when I think the Attorney General was about as important as a cabinet officer as anybody else in the cabinet. And this is now early 1940, late 1940, early 1941, when FDR is trying to figure out how to help the British, especially in the war effort against Germany, when the US is not yet part of the war, where Congress refuses to actually pass much in the way of affirmative authority for any kind of support. This is before Lend-Lease even. And so, Jackson writes a memo in his capacity as Attorney General, rationalizing why FDR can basically trade destroyers for access to military bases, and why he can do that without Congress, why that was not an abuse of executive power, and basically a sort of an early planting of the flag that in this context, the president actually has a fair amount of unilateral authority to take steps in the interest of national defense. And one of the really interesting things about that opinion, I don't think we would ever imagine this happening today. The opinion is reprinted in full in the New York Times. I mean, this was a big deal when it happened. And it was, I think, a lot of folks' first exposure to Jackson as a national figure. And it's in defense of executive power even before the US formally enters World War II.
Yep. And we had a guest center last summer, Bill Casto, who had written a book about Justice Jackson advising FDR during his period time as the Attorney General. And a lot of the tension sometimes that I think people struggle with is the Attorney General is still in the executive branch. And so it is a matter of sometimes, and this is something sort of in my training of, can I help you get done what you need to do? The answer isn't always. The answer sometimes is not the way you want to do it, but let's figure out how to get there. And this is one of those decisions that sort of brings that to mind.
I think that's right. And I think, it is a common, debate across modern American history, whether and to what extent the Attorney General should be independent of the president, and whether and to what extent the Justice Department should be independent of the president. For better or for worse, the constitutional structure we have, at least at the federal level, is that the Attorney General is not independent. There are plenty of states that actually separately elect their Attorney General. Texas is one of them. And I think, Jackson, one of his most famous writings before he becomes a Supreme Court justice is his speech about being a federal prosecutor. And I think, he understood and was able to articulate, I think because he was such a powerful writer, the dual obligations of government lawyers in general and of the Attorney General in particular of, being a counselor to the president and of being the nation's chief law enforcement officer, but also not being beholden to the president in the way that, say, the president's personal lawyers might be, in a way that what we now think of as the White House counsel is. And, it's a fascinating counterfactual to wonder what would have happened if Jackson had stayed longer in his post as Attorney General, as opposed to moving so quickly, down Pennsylvania Avenue to the Supreme Court.
Absolutely. Well, and so then we move from just stories for basic sticking in a historic context, and probably Nuremberg, although he had some opinions prior to him moving to Nuremberg for that trial that also show perhaps inform some of his shift in thinking on executive powers. You want to pick something up there?
Yeah, I mean, I'm really just a student of other people's better scholarship on this front. But I mean, Dennis Hutchinson, for example, has written, I think, quite beautifully about Justice Jackson's role in the Japanese internment cases. Jack Goldsmith has a really nice paper about Jackson's unpublished opinion in Ex parte Quirin, the Nazi saboteurs case from the middle of the summer of 1942. And one of the things I think is really interesting is there really is this, I think, decided evolution over time from the Jackson who writes the unpublished opinion in Quirin, which is remarkably pro-executive and really is critical of the court only insofar as the court is assuming the responsibility of deciding the case, as if like the court should just stay out of it, to Hirabayashi and Korematsu, the court's two major internment decisions, where I think Jackson again is not really sure the court should be part of the story, but is increasingly skeptical that what the executive is doing is above board, to his experience at Nuremberg, and then all the way up to the Steele Seizure case, where his famous opinion, which I know we're going to talk about in a bit more detail, he ends it with a couplet from, I think, Kipling, about how it should be the court should be the last institution to give up fealty to the rule of law, not the first. And that's a very different view, not just about executive power, Kristin, but about the court's role in supervising executive power, from the Jackson who, even in his Korematsu dissent, thinks that the right answer was for the courts just to stay out, not like Justice Murphy, for the courts to actually strike down the policies that the FDR administration was pursuing. So, we can't ever sort of conflate correlation and causation here, but I think it's telling that Jackson after Nuremberg is much more nervous about courts deferring to the executive too much than Jackson before Nuremberg, where he actually, I think, spends a lot of time wondering if courts should have anything to say in some of those high-profile executive power contexts.
Well, I have to imagine that some of that is also informed by one of the later Nuremberg judges trial, where the conversation really was, and I've had this conversation once before as well, the concept that the rule of law doesn't necessarily always mean it's a positive thing is always a hard realization to come to. And so under the Nazi regime, it's basically upheld all of the laws that the government perpetrated against the Jews and gypsies and all the targeted groups. And so I think that probably also factors into some of Justice Jackson's analysis.
I think that's right. I think the justice trial from the Nuremberg Military Tribunal, the second round, right, what was surely fresh on his mind, even if he wasn't as directly involved in that one. But you even see a thread of it even before Nuremberg, again back to his Korematsu dissent, where that opinion gets quoted a lot for the loaded gun metaphor, that the decision upholding this kind of policy lies about like a loaded weapon waiting for any claim of urgent need. And I think the message sometimes gets a little bit diluted. Right? What Jackson's saying is that there's a huge difference between governments overstepping in times of crisis, which he thinks is all but inevitable, right? That it's just, it's not only is it pointless trying to stop that from happening, but there may be circumstances where we want that to happen, where we want overzealous responses, versus courts coming in and rationalizing the overzealous response, right? That to Jackson, the sin to the rule of law is never the underlying violation by the executive. It's the second order ruling by courts that either directly or indirectly rationalizes and legitimizes that violation. And I think that's the part of his dissent that sits with me the most, and that I think it's revealing to me that that's before Nuremberg, right? And that, he's already thinking that way even before he goes off to spend the better part of 2 years as the chief prosecutor at the IMT.
Yeah, absolutely. And then, so you mentioned the steel seizure, which is obviously his most famous case regarding this. So why don't we talk about that? So this is to set the scene for people who are not as well versed in this. This is 1952. It is the Korean War era. The President Truman, wanted to sort of federalize the steel production in the country. So 1952, why don't we start with what did the court ultimately decide in that role?
Yeah, I mean, so the case, whether you call it by its formal name or by its common name, the Steel Seizure case, Youngstown Shooting 2 versus Sawyer, it's become canonical really in law school. I mean, I think it's one of the few cases I'm fairly comfortable betting almost every first year law student will read in their constitutional law classes. And the court ultimately rules against Truman. And I think by a 6-3 vote, the court says Truman's effort to basically take over the steel mills to ensure a continuous supply of steel in the middle of the Korean War was unlawful because it was not justified and authorized by Congress. And it's a remarkable decision in a couple of respects. One, it is the rare example of a wartime Supreme Court pushing back against wartime actions by a president. Indeed, this is one of the big themes of Chief Justice Vinson's dissent, is that the court shouldn't be interfering with the president during wartime. Two, by 52, I mean, the personalities on the Supreme Court are so deeply entrenched. I think scorpions in a bottle, right, is the metaphor that what Frankfurter uses. And they can't agree on one opinion. So all 6 of the justices in the majority write their own opinions about why they think Truman's wrong. Which is, it's how we used to do it at the very beginning of the country, but not how we really had done it since 1801. Right. And so there are 6 different opinions espousing the better part of 3.5 or 4 different theories about exactly what was wrong with Truman's efforts to seize the steel mills. And so you've got, Justices Hugo Black and William O. Douglas, who are very formalist, who say, listen, you can't point to a statute, Truman, that says you can do this, therefore you lose. You've got Justices Burton and Clark, who are sort of in the middle, right, who say, well, if Congress hadn't done anything, this would be a harder case, but Congress has actually legislated in this field and has not provided this authority, so you lose. And then you have Jackson and Frankfurter, who really, I think, are the 2 justices in the majority who found this case to be the hardest. Jackson writes really a fascinating essay on the history of executive power, with lots of classically Jackson one-liners about like how you could match, a Jefferson with a Lincoln, you could match a Roosevelt with Taft, and you could even match President Taft against Professor Taft, right? And what he's trying to say is that there's no one clean line that sort of describes how the Supreme Court has historically understood executive power. And so instead, he offers what has become this celebrated tripartite taxonomy, the 3 boxes of how to understand separation of powers disputes. Box 1, where the president and Congress are on the same page. Box 2, where it's just not clear what Congress has or hasn't done. Box 3, where the president and Congress are at loggerheads. And what's really interesting about Jackson's opinion is, even though he says this case is in box 3, that's only the beginning of his analysis, not the end. He still has to explain why in box 3, the president's power, although it's at its lowest ebb, is not 0, but it doesn't cover this. And so part of why I think Jackson's opinion has become so celebrated is because it's the most candid, I think, assessment of how the Supreme Court has looked at and should look at these kinds of interbranch disputes over executive power.
And this reminds me of, so for those of our audience who are also looking for other things to read, Man is a book that Justice Jackson wrote, also more or less in this time. It, at least from the forward of it, was written by the Jackson Center's Jackson scholar, John Q. Barrett. Part of this was he was a little bit astounded by the arguments that the United States was bringing, and they kept citing back to the work that he had done during his time advising FDR. And so, you know, he looked around and realized he was the only person still alive who in those meetings and had understood the background behind those decisions and his advice. You know, I think one of the things he points to is the fact that, and I'm remembering which case it was off the top of my head, but there had actually been a contract with the government. And so that was one of the reasons he had used the justification of, yes, the government can actually take this over because there's an outstanding contract there, which he did not see that same parallel in Youngstown.
I think that's right. And I think also, I mean, for both Jackson and Frankfurter, the Korean War was just a very different conflict than World War II. And so I think they also both had this feeling, which Frankfurter actually, I think, expresses overtly, and Jackson sort of dances around his opinion, that the president probably has different powers in the kind of total war like World War II, where Congress has formally declared war, than in a, you know, police action like the Korean conflict, where, you know, yes, tens of thousands of Americans were fighting and dying, hundreds of thousands of Americans were fighting, and yet Congress had not fully activated the sort of domestic war machinery. And I think, you know, Frankfurter says at one point, you know, we haven't gone to war in the only constitutional sense in which we can, which, you know, suggests that maybe there should be a different test, or at least a different thumb on the scale, depending upon what kind of war we're in. And I think that looms large, especially today, because, you know, we don't declare war anymore. I mean, the last country the United States declared war against was Romania in 1942. And so, you know, in a world in which executive power really is different during an all-out total declared war, and more sort of imperfect limited wars like the ones that we've been fighting for the better part of the last 70 years. It seems like that's lends itself to more decisions like Youngstown, and fewer decisions like the Nazi saboteurs case, you know, Kieran.
Yeah, that makes sense. And that's actually a good segue into some of the Defense Production Act uses today. So, you know, for the last about 2 months, you know, 6 weeks, I feel as if sort of once a week or so, there is some article, podcast, blog post, news article, something like that about the Defense Production Act. You know, it's as we said at the beginning, it had its genesis in the War Powers Act that was enacted during World War II. It's one of those laws that needs to be reauthored periodically, which I think not everybody is probably aware of. But why don't we start with the basic? What does the Defense Production Act enable the government to do?
Yeah, so I think it's worth, if I can even take a step further back, right? I mean, it might be also worth placing in context why it exists in the first place. And I think, you know, there is a remarkable flurry of legislation in the decade after World War II, where Congress is responding to fairly fundamental gravitational shifts in the relationship between government and industry, and how increasingly public-private partnerships are at the front lines of national security, of defense, and so on. I mean, so, you know, this is the same Congress that passes a statute called the Invention Secrecy Act, right, which actually for the first time takes, you know, principles of national security and applies them to, you know, ordinary things that companies are doing in their labs, right? And I think it's all part of the sort of dramatic reconfiguration of the government of what Eisenhower is going to call the military-industrial complex, you know, less than a decade later, where Congress is trying to figure out how to legislate for circumstances in which the government's reliance upon the private sector is actually a liability. And so the Defense Production Act is basically saying, you know, there could be circumstances where the government needs to take fairly aggressive action to ensure a continuous and sufficient supply of products and commodities and goods and services that are necessary for the national defense. We don't want to have to nationalize these industries. And so what can we do short of providing for government takeover, which has all kinds of problems, political and constitutional? What can we do short of that to actually ensure that this system is preserved? And so the DPA is actually this really interesting series of compromises, where the government is basically allowed to take a series of increasingly coercive steps to basically shore up production of needed goods, to ensure a sufficient market for particular resources, to provide incentives to companies to produce and sell particular goods over others, all in the name of national defense. And so, this statute's been on the books for 70 years. It's been used thousands and thousands and thousands of times, almost always out of sight and out of mind, because no one gets especially exercised when the Department of Defense issues a DPA order to secure a supply of titanium sponges. I just choose that example because that's the last one they issued before the coronavirus pandemic. Gotcha. So, it's a statute that just has so many uses that we just don't see, where it's just behind the scenes, often but not always the Department of Defense, just looking at the sort of services and goods it needs from the private sector and ensuring an adequate supply and preventing a market pressure from actually impairing national security.
Mm-hmm. And so I think that I think one of the things that you touched on there is something that I don't think people realize is how often it's used. And I think President Obama delegated its use to the State Department and some maybe different branches of the military as well. Obviously not my area of expertise, so if I've gotten anything wrong there, let me know. But I think that people just don't realize the fact that it is used often as it is. It seems like it's this one very big thing, and it's and part of the president sort of frames it as, okay, we're not breaking that last seal for this. And so, that it just builds it up as if, oh, this is something we never use.
And I think this is true. I mean, Chris, I think this is true more generally about what I tend to think of as the big three federal emergency response statutes, which is, I think, all three of them are actually used on a fairly regular basis. It's just that we tend not to see it, and we tend not to get sort of, it tends not to be a big political deal when they're used. So, in addition to the Defense Production Act, there's the Stafford Act, which is the 1970s era statute that it's complicated, but basically at its core is about reallocation and repurposing of federal funding for emergency and disaster assistance. So when the federal government is sending money to governments, to local and state governments, that's usually Stafford Act territory. FEMA, right? That's usually Stafford Act territory. The Public Health Service Act, which is where just about all of the federal government's coercive powers with regard to quarantine come from, is actually used for far lesser things all the time. I mean, the CDC gets most of its authority from that statute. So, I think that there are all of these. When we talk about executive power, I think it's really important, and I think this comes through loud and clear in Jackson's opinion in Youngstown, to differentiate between executive power that the executive has by dint of statutory delegation, and executive power that the president has because Congress has done nothing, and executive power that the president has even when Congress has said otherwise. Right, that those are really the three categories Jackson's talking about in his concurrence. And what's, I think, really telling about so many of the conversations we're having today is that the executive power that's most at issue at the federal level in response to, say, an unprecedented global health crisis is almost all in the first category. It's almost all in the category of things Congress has delegated to the president, where it's just a question of whether the president is going to fully activate the authorities he's been given.
So we keep using, as everybody does, Justice Jackson's concurrence in the Seal Seizure case as, our outline of metrics of how we analyze this. But are there guidelines for the amount of scrutiny that the courts or Congress should be giving to these exercises of executive power? So let's take, I guess for that, we sort of need to stay out of the first bucket of let's assume there has not been delegated to the executive. how then do the courts or Congress look at it? I know there are instances with Congress coming back behind retroactively, affirming the decision. So talk us through some of that.
Yeah, I mean, I think, part of why I think Jackson's concurrence is so widely quoted is because he's speaking for a lot of our intuitions, right? That, it's not that Jackson, at least in this case, it's not that Jackson is just leaps and bounds smarter than everybody else. It's that he has a way of turning into prose ideas that resonate with us when we say them out loud. And I think that in this context, courts operate much the same way, that courts are loath to disturb actions by the president when it's clear that he has the support of the legislature, and are only going to do so when it's pretty clear that it's in violation of some constitutional provision or way in excess of the federal government's authority. But that courts are more skeptical when the president's acting on his own, either because Congress hasn't said anything or because Congress has said the opposite. And I think, a really good example of this, I think we've seen two good examples of this across each of the last two administrations. So with the Obama administration, we saw a lot of skepticism in the immigration context, with Obama's authority to promulgate DACA and DAPA, these deferred action programs for, in DACA's case, for non-citizens who came to the US without status when they were very young, in DAPA's case, for the parents of those individuals. And now in the Trump administration, with how President Trump has used authority that Congress didn't really mean to cover the border wall, to repurpose military construction funds, right, for the border wall. And, in both contexts, what the president's doing, neither Trump nor Obama in these cases claimed the power to act unilaterally. They both claimed that they were simply acting consistently with the statutes Congress had authorized. And yet in both cases, we know that the specific things they were doing were things Congress had just directly rejected. And so these were workarounds, right? These were sort of, lawyerly efforts to find authority through the back door that Congress had just closed the front door to. And I think, one of the things that comes through in Jackson's concurrence, but I think is just a proposition that comes across almost all cases, is that courts are wary of backdoors. And whether that's expressed formally or whether that's just a thumb on the scale, you see more skepticism of situations where it looks like the government's using authorities that weren't earmarked for those purposes versus cases where they clearly were.
Mm-hmm. To imagine that to go back just to the general rule of a lawyer is, you have to, the advice isn't always necessarily what is the most straightforward path. The advice is, how can I help you accomplish what it is you're trying to accomplish, staying on the right side of the law.
And I think, in the context of the Defense Production Act, I think the real complicating factor is not the limits of the statute, right? I think unlike some of these other contexts, in the DPA context, the real complicating factor is politics, because there is such a, I think, deeply rooted aversion to government interference in the private sector among many of our, fellow citizens, among many members of Congress. And that's what the DPA looks like and feels like. And so I think there is some, sense that, yes, there are all of these sort of small fry DPA invocations. No one's going to get worked up about titanium sponges. But when it comes time for the president to use the DPA against, say, General Motors or GE or, large companies making everyday products, or, with regard to the meat industry, that's when we're not necessarily entering a legal thicket, but we are entering a political thicket where you have countervailing concerns of both federal overreaching and of federal interference in the market that I think are pushing back against some of the authorities that are clearly there.
And since the Defense Production Act in its name has defense in it, I think it's a natural inclination to assume that really this only should be used in time of war, or when we are defending ourselves, let's say, from some outsider, as opposed to an internal situation, recognizing a global pandemic, not necessarily an internal situation, but there's not a physical force that we're fighting against. And so I think that that's part of the struggle there is, and from the plain reading of the statute, was the intent for it to be used as possible, or was the intent really for it to try and be used more in a defense or time effort?
So, I mean, I think it's evolved. I mean, I think the Congress that enacted the statute in 1950 was not thinking about a global pandemic when it wrote the statute. But there are amendments to the statute that are much more recent vintage that I think are much more in support of the notion that that defense is a capacious term. And I don't think it should be much of a stretch to suggest that the coronavirus has major implications for our national security, even if it's a purely freakish act of nature or of biological nature. And this is a Rubicon we've crossed really 40 years ago for natural disasters, right? That a number of the authorities that had historically been reserved for man-made and military emergencies have now been extended to the natural disaster context. And I think, pandemics strike me as being of the same ilk because of their disruptive effects, right? That it's the disruption to ordinary functioning of society, ordinary functioning of the market that justifies the resort to the extraordinary measures. I think that's why, the criticisms you hear of the DPA tend not to be that it shouldn't be available in a pandemic, right? It's that it shouldn't be used until it's absolutely necessary. And I think that's where we get into a fight about, what is the responsibility of the government? Is it the last resort or is it the first line of defense? And again, that's why I think this is more a political debate and controversy than a legal one.
And so I would imagine I'm going to ask you to be a little bit prospective at this point. So if I recall, the next reauthorization for the DPA is in 2026. Mm-hmm. And so do you think there will be an effort made to be a little bit more explicit? So you mentioned that over the course of its history, it has changed, it has morphed to acclimate the situations. Do you anticipate that in the next look at this very experience, which will only have been about 6 years ago at that point, will be part of that calculus?
I'm sure it will. I hope this is the last experience we have that factors into the calculus of the 2026 DPA reauthorization. Again, I think it's too soon to tell, right, what the history of this year is going to look like when it comes to the coronavirus response. But I do think that if there has been a problem with the DPA, it has been trigger shyness on the part of the executive branch, and not the fact that the statute doesn't allow it to do what it thinks it needs to do. That we've seen. I mean, we've seen, for example, the president move slower than I think I would have liked to see him move. Although I realize reasonable people can disagree when it comes to using the DPA to line up access to ventilators and then to PPE and now to the meat industry. We've seen situations where the president has signed these much ballyhooed executive orders under the DPA that merely just give authority to somebody else who then has to actually use that authority, and we haven't necessarily seen the follow-up. So, Kristin, I guess where we are today, and it's just May 14th, and I don't even think we're halfway through this crisis, but where we are, I just think that the story that's going to emerge about the DPA is one of it not being used the way it could have been, as opposed to one of Congress not providing the government the tools it needed.
Okay. Well, why don't we take a deeper dive into, in my mind, I guess, sort of the two main ways it's been used so far. So you mentioned General Motors and the ventilators, and then obviously with the meat packing. I guess I'm just going to stop me talking there and turn that over to you. But so talk us through sort of its use in both of those cases.
Yeah, I mean, so just to get into the nuts and bolts of a pretty nutty and boldy statute, I mean, there really are sort of three different layers of authority in the DPA, at least as it exists today. And the first layer is, I think, probably the least controversial, which is just that the government's allowed to spend money for goods that it needs directly. And basically just a lot of authority to take money elsewhere appropriated to different government agencies and spend it on stuff. And so if the government itself wanted to use the DPA to procure 10 million tests for coronavirus or 100,000 N95 masks, that's right up front in the DPA, and the government would get to be the preferred buyer. I mean, that's the idea is that the government doesn't have to go get in line behind you and me and the states of New York and Texas. Where things get, I think, a little more controversial is it also gives the government the power not just to directly buy stuff, but to tell companies which of their contracts to prioritize. So to allocate resources, to basically pick and choose and play favorites among not just particular companies, but particular contracts held by particular companies. So, hey, GM, you've got this contract and that contract. We want you to perform that contract first. That's aggressive, but it's not actually forcing GM into a contract it had not already made. It's just basically sort of a priority allocation. And so what we've seen with the ventilators and to a lesser degree the masks is some variation of both of these, where in some of it, it's been the government just paying to buy a whole lot of stuff. And in some of it's been saying, we want you to actually shift your production capacities to meet this contract, right? In a way that I think is pretty much about as aggressive as we've seen the DPA use, but just one example of that, right? Versus the meat industry context, where I think the headlines got way out over their skis compared to what the government actually did. So, there were these sensational headlines that President Trump was ordering all of these meat plants to stay open. And I was sort of puzzled by that because I couldn't understand, the headlines were about 10 hours ahead of the executive order. And I couldn't understand how an executive order could say that if the DPA doesn't say that. And, the executive order doesn't say that. The executive order says the Secretary of Agriculture is allowed to use the DPA to prioritize meat production as a critical resource, which means Secretary Perdue can bring to bear these priorities, these allocation authorities, et cetera. He can prioritize PPE to the meat industry, right, to sort of facilitate production. He can order companies to fulfill contracts, which I guess could theoretically require some of them to operate at a level beyond which they otherwise would choose to do so. But that doesn't strike me as remotely being the same thing as forcing them to stay open just to stay open. And so I think, there's just a lot of misinformation and a lot of, I think, uncareful reporting about both what these authorities are and, as importantly to me, Kristan, what they're not, right? And they're not by design. I mean, I think the DPA would have been very, very different if the authority included the authority to keep these plants open. Indeed, just to sort of tie threads together, if the DPA provided the authority to keep meat plants open, presumably it also would have provided Truman with the authority to keep steel mills open, right? And so, I think it's a rather telling piece of the story that the Defense Production Act is not part of the story in Youngstown, right? That it was not understood as sort of a general authority to take over private industry, but rather as a series of much more specific targeted powers.
Right, and to wrap this back even further, back to Justice Jackson's arguments during his time as Attorney General, also goes back to there are contracts, and so right. it's providing the vehicle for seeing the contracts are fulfilled. Right. And yes, in certain circumstances, that may mean the company is something it might not otherwise choose to do, but the government has prioritized this contract.
And to that end, right, and so the DPA does have these two immunity provisions, right? So to protect the companies from basically being forced to break the law, right? The DPA says you can't get damages against a company for anything it does consistent with an order under the DPA. Of course, that gets misinterpreted by contemporary commentators as saying, now like workplace compensation laws don't apply in the meatpacking industry. That's not what it says at all. It says if plant X is only producing this product because it was ordered to do so by the government, and that particular operation injures you, then plant X is immune, but not like in general. But there's also, and this is, I think, to really get at the heart of what's going on here, there's an antitrust immunity provision right? Because one of the things that the DPA is really about is it's about getting companies to do things, maybe even together, that they're not usually allowed to do, right, to fulfill these contracts. And so I think that really goes to the gestalt and the zeitgeist of this whole sort of phenomenon, which is, the idea is not just, government, do what you need. The idea is there are contracts. The government can pick and choose which ones are the most important. The government can actually be parties to those contracts, and the government can use the contracts to shape what the output from industry looks like to meet some kind of national defense emergency.
That's really interesting. I practiced, I was an antitrust lawyer for many years. And so that's something we would often, there are a lot of benefits certainly to companies working together. How does that manage? And there is, for most things, a carve out when it is ordering you to do something, or the federal government ordering you to do something. And so, that's certainly not inherent or just in the DPA itself either. So, that's a broader piece that although people might feel squeamish about it in this instance, is always there.
I think that's right. And I just, it's
all right.
What,
no, go ahead.
No, it's because I think one of the things that, one of the things I find most frustrating about, contemporary debates is that there are really interesting, rich nuances to a lot of the authorities we're fighting over. And the contemporary debates happen mostly at such a superficial level where, nuance is irrelevant. And all that matters is, who's on which side. As I instinctively rebel against that.
Justice Jackson would approve as a great debater himself. He would appreciate your love of the nuance. We're going to take a pause for a moment to see if there are any questions. When you and I were talking as we were setting this up, you had mentioned that you have a special mug into your Jackson Center mug.
So in addition to my Jackson Center mug, yes. So as a thank you for a talk I gave a couple years ago, some students from Harvard Law School gave me this mug, which is basically, it's a mug for the Jackson concurrence in Youngstown, and including the sort of the cites to the opinion. On the back, there are three sort of levels, and the top of the glass is the first box for Jackson, where the president's authority is at its maximum. There's the middle where you're in the zone of twilight, and then there's when the president's authority is at its lowest ebb. And so the beverage in the glass, I guess, is the president's power. And as time goes on, you drink the president's power away.
That's, I'd love to get my hands on one of those glasses. To reach out to Harvard Law School and see if there are any left. We don't have any questions at the moment, so why don't we've talked about some of the common misunderstandings that the public has about the DPA, but I guess what is the best way for our audience to educate themselves, or more, I guess the question is how to think critically about these news stories that they're seeing about its use? What would you recommend?
Well, I mean, I think the most important thing is, where possible, go to the primary source. And the DPA itself is a pain in the butt to read because it's long and it's complicated, and a lot of the provisions don't make intuitive sense. But when the president issues an executive order, read the executive order, and don't be distracted by the politics, right? Don't be distracted by the language, like the findings, right? Look at the operative provision. What does it actually say he's doing? And I think even lay people would be, I think, pleasantly surprised by how obvious it is that the operative language doesn't say what many of the headlines says they say. Where possible, read the statute. I mean, I try really hard. I am active on Twitter, perhaps as my wife would be the first to say, too active on Twitter. But I try really hard whenever we're talking about a statute to actually post the text of the statute and a link to the statute, because I don't expect people to agree with me just because I'm me. I expect to, folks to be able to read the sources and actually see what the analysis is grounded in. And I think there's just way too much path of least resistance today, where it's like, oh, commentator I often agree with says this, so it must be right. Or, source of news that I always get my news from says this, so it must be right. And I think, we should all know enough to know that that's just not true. It's that no one is ever perfect. And that the best thing you can do is, as Ronald Reagan said, right, trust but verify. And so I guess the DPA is a particularly hard case, but I actually think, it wouldn't have taken that much digging with some of the president's DPA orders to see just how little they were actually doing, even on their face.
Mm-hmm. All right, we did get a question in from Helena. The question is, what recourse would states have if the prioritization of resource allocation is to favor one region of the country over another?
It's a great question. And here we're in a bit of uncharted territory. I mean, I don't think we have a lot of historical examples of the federal government, at least by some appearances, picking and choosing which states to fully versus less fully support for what may very well be political reasons. There's a decision the Supreme Court handed down about 7 years ago called Shelby County versus Holder, which is especially controversial because one of the things the court did was it struck down a pretty important part of the Voting Rights Act of 1965. But the reason why the court struck down that part of the Voting Rights Act was because the court said it failed to respect the, quote, equal sovereignty of the states, unquote, right? That is to say, Congress was treating states differently based upon Congress's perception of whether they had acted properly or not. And, I think it's only a matter of time before we see some litigation where states that have had a harder time accessing resources, where states that have had some of their Stafford Act funding withheld, really do actually try to take that Supreme Court decision out for a ride, and see if they can, get the federal government into court. The Supreme Court over the last 35, 40 years has been very, very nervous about circumstances where the federal government is coercing state behavior through funding. And when the president goes on television and says, I will give you your disaster money if you stop providing sanctuary to undocumented immigrants. I actually think that's hard to reconcile with a lot of what the Supreme Court has said about spending conditions. So I think the recourse is first and foremost political, which is to say, there's an election coming up in November, people should vote. But I think, the states are going to, if this persists, take President Trump to court, and it's not clear to me that they're going to lose.
Interesting. All right. We did get also a question. This is going to be, I think, perhaps going to require many more minds than just ours. But it's the question is related back to your comment on executive orders and how to encourage perhaps media to publish the primary sources and or to be more accurate. I think one of the challenges we run into is with the 24-hour news cycle, there's always that I've got to get out first. I've got to find the next story. I've got to find my own spin. And even if we end up reporting the same story for a 48-hour cycle, but different nuances or different aspects of it, it's just one of the challenges we have in our 24-hour news world.
Yeah, I mean, I don't think I can solve that. I do think,
as I said, we need many more minds on this one.
So, I one of my part-time gigs is I help CNN cover the Supreme Court. And so one of the things that includes is anytime the Supreme Court is handing down opinions like this morning, or orders, which it'll do on Monday, we have an all-hands conference call. And, it is always clear in that context the pressure to get out with a headline. But it is also, I think, really impressive just how careful folks are about making sure the headline is exactly right. And the reason why they have me is to help make sure that we're not missing legal nuances, right? That might not be obvious to a popular audience. And so, I just think I resist the notion based on my own personal experience that speed and accuracy are mutually inconsistent, right? I think they are, light speed and accuracy might be inconsistent. But, there are plenty of folks who are pretty quick readers who are also pretty good authorities on the fields they're covering. I think, part of the problem is the more general, I don't want to say demise of expertise, but devaluing of expertise across any number of contexts where, it's less important to have people who know what they're talking about than people who can say it loudly. But one of my least favorite quotes about Justice Jackson is it's a Justice White quote, where one of Justice White's law clerks brings a memo that he wrote to Justice White, and Justice White says, "You write beautifully, And the clerk gets all excited. And then White says, Justice Jackson had the same problem. Right. And White was taking a shot at Jackson for sort of using the power of his prose to sometimes mask his own uncertainties, right, and indecisiveness on some questions. And I think
Yes.
we should all be a little Jackson and a little White. We should all be willing to write quickly, right, but also write correctly. And I think that I resist the notion that those have to be mutually exclusive, even in today's nasty, toxic, polarized media climate.
Yep. Yeah. I feel that you touched on something I feel like I've been seeing a lot in the news as well recently, is that those to rely on the experts to basically everybody, because they have access to basic information in the world, is starting to think of themselves each as an expert in whatever the field is. And so there's the evaluation, as you were saying, of this person has actually studied this for his entire career. He's going to know more than 97% of the people out there.
I mean, which is so if it's fun to have this conversation through Jackson quotes. But my favorite Jackson quote is actually from a case called Brown versus Allen, where he's talking about federal review of state convictions through habeas. And Jackson's trying to explain, I use this all the time to talk about the Supreme Court supremacy. And he says, we're not final because we are infallible. We're infallible because we are final. Right. And so I think, I don't want to suggest for a moment that people should blindly defer to the experts, right? That's not that's not it at all. But just if I can use one very recent illustration, I mean, so one of the big news stories of the last few days has been the government's effort to drop the criminal case against former National Security Advisor Michael Flynn, and just without getting into anything about Flynn, I mean the federal rules of criminal procedure make it abundantly clear, if you just read them, and it's not hard, just one sentence, that such a measure requires, quote, leave of court, meaning you need the court's permission. And the government itself concedes this. It filed a motion to dismiss the Flynn case. It didn't just say, we are dismissing the Flynn's case. And the number of headlines that just instinctively said, DOJ dismissing Flynn case. And then this produced this backlash when all these commentators were like, no, actually, DOJ can't do that unilaterally. When all it would have taken is looking at the relevant rule for about 5 seconds to see that it says with leave of court. So I just, it's not that the experts are infallible. We're not. It's just that, we can probably point to the relevant text, and then we can fight over whether the authority says what we think it says or what the other person thinks it says. And sometimes we're going to disagree, and that's why we have courts and judges. But a lot of times we're not going to disagree. And I think that's what gets missed in a lot of the contemporary messiness of our discourse.
Mm-hmm. So we did just have a comment from Chris come in, and wondering if you could talk about, is there benefit to, let's basically call it an override mechanism. So, if an executive order is attempted, and then, executive order is not attempted, if an executive order is signed, and then Congress or the Senate come back or take a look at it, and they're like, no, this is really not something that we want to have happen. What is the recourse there?
So, I mean, this is where I think the Supreme Court has complicated things. So in the old days, there were a lot of contexts in which Congress passed statutes to delegate authority to the president, where one house of Congress, or in some cases, both houses of Congress, could disapprove the conduct. And these were called legislative vetoes. And they were struck down by the Supreme Court in 1983 in a case called INS versus Chadha. And just to sort of illustrate why that matters, the National Emergencies Act is a great example of this. So the National Emergencies Act was passed in 1976 as a way of actually streamlining and regularizing presidential emergency declarations. It imposed all of these procedural limits on emergency declarations. It said they all expire after a year unless the president reauthorizes them. And it gave Congress the power to terminate any national emergency through a concurrent resolution, meaning a resolution that goes through both houses but doesn't go to the president. And so in that context, if the president declared a national emergency and Congress said, what are you, this is not, how could what this is not what we had in mind when we said national emergency. All it would take is a majority vote in both houses and the emergency would be terminated. Well, in Chadha, the Supreme Court says, nope, you can't do that. No, legislative vetoes are unconstitutional because Congress is basically legislating without following the bicameralism and presentment rules of Article 1, Section 7. And so Congress responds to Chadha by amending the National Emergencies Act. Now, if it were up to me, I would have said, all right, well, if we can't have this power, then we're not going to give it to the president in the first place. And so I would have had the, I would have changed the situation from, instead of it expires in a year unless the president just reauthorizes it, I would have said it expires in a year unless we reauthorize it, right? Instead, Congress passed a statute where it says, all right, fine. We can't do this through a concurrent resolution. We'll do it through a joint resolution, which is both houses of Congress and the president. Small problem. The president's not going to sign a joint resolution terminating an emergency that he declared. And so this is exactly what happened with the border wall. President Trump, I think rather controversially, declared a national emergency to allow him to unlock access to all these funds Congress wouldn't otherwise give him to help build the border wall. Both houses of Congress voted to terminate the emergency, including the Republican-controlled Senate. The president vetoed the termination resolution, shockingly. And it went back to Congress, and there weren't enough votes to override the veto, right? I mean, and so, here we run into the problem where a world in which Congress can only take back power if it has a veto-proof supermajority in both houses is a world that we don't live in. Because the last time one party had, I think, veto-proof supermajorities in both houses was 1965, when the Democrats, I think, had veto-proof supermajorities in both the House and the Senate. So I just think, the right answer is some combination of more aggressive judicial review in these cases, to hold the president more closely to the underlying statutory delegations, and much more foresight on Congress's part to not allow these delegations to become permanent, to sunset a power. I mean, just to sort of, Kristan, you already mentioned the sunset in the DPA. One of the only other national security authorities with a built-in sunset is part but not all of the Foreign Intelligence Surveillance Act. And 3 of those provisions actually were allowed to expire in March because Congress could not agree on whether to have a clean reauthorization or whether to pursue amendments. Just today, the Senate actually finally approved a bill that would reauthorize those provisions plus a couple other things. Now it has to go back to the House, right? So I'm much happier in a world in which Congress is, the lesson of Chadha, the lesson of the last half century of executive power is that once Congress gives the executive power, the executive is not giving it back. It's hard for Congress to take it back so long as, politics are going to be as important as, so long as the separation of parties is going to be as important as separation of powers. And so in that world where Congress is not going to take it back and the president's not going to give it back, the only answer is to not give it in the first place, or at least to give it with a time limit. And I really wish we saw more of that from Congress in the national security space especially, but across a whole number of topics.
Okay, well.
Now you got me fired up.
No, that's great. That's great, actually. And I wish we could talk about this for another hour. I've promised that the teas will not last quite that long, but perhaps you will be willing to come back and we can explore this part of it. Thank you so much for being our tea guest today. I really appreciate it. Also, just a reminder for next week's tea, I will be talking with Navi Pillay, the former UN Commissioner for Human Rights. A reminder that she and I are taping that tomorrow morning. So if you have any questions for Navi, please email them to info@roberthjackson.org by this evening. So I have them for tomorrow. And we look forward to seeing you all next week. Steve, thank you again very much for being here.
Thank you.